Friends, welcome to my YouTube channel Legal Information Law Insights. I am Advocate Mukund Mahajan. Firstly, I am pleased to share that yesterday I have received the YouTube Silver Creator Award. This recognition reflects the trust and support of all of you who have watched, shared, and encouraged my work on Legal Information Law Insights. I sincerely thank each one of you for being a part of this journey. Your support motivates me to continue spreading legal awareness and knowledge for the benefit of society. Friends, if you find our content useful, please consider becoming a channel member by contributing 59 rupees or 119 rupees via the GPay QR code shown on your screen. Your support helps us continue providing high-quality legal education. Now, let us move on to the subject of this video. As per the press release dated 24th April 2026 issued by the Reserve Bank of India, the license of Paytm Payments Bank Limited has been cancelled with effect from the close of business on the same day. The link of the said press release is provided in the description box. But what does this mean from a legal perspective? Is your money safe? And what happens to the Paytm app? Let us understand this step strictly from the lens of law. 2. Legal framework under the Banking Regulation Act, 1949. The RBI derives its authority to grant and cancel banking licenses under the Banking Regulation Act, 1949. In the present case, the cancellation has been exercised under Section 22(4) of the Act. This provision empowers the RBI to cancel a license if it is satisfied that the conditions prescribed under the Act are not being fulfilled. 3 grounds for cancellation of license. As per the RBI's findings, multiple statutory grounds under Section 22(3) were invoked. The RBI formed an opinion that the affairs of the bank were being conducted in a manner detrimental to the interests of its depositors, which directly affects public confidence in the banking system. Further, the general character of the management was considered prejudicial to public interest, indicating serious concerns regarding governance and regulatory compliance. The bank also failed to comply with the specific conditions subject to which its license was granted, which is critical in the case of payments banks operating under restricted regulatory frameworks. Lastly, the RBI concluded that allowing the bank to continue its operations would not serve any useful purpose in the public interest. 4. Regulatory process before cancellation. It is important to understand that such a cancellation is not a sudden action. It is typically preceded by continuous regulatory supervision, inspections, and opportunities given to the entity to rectify its deficiencies. This reflects the principle of fairness and due process in administrative action. 5. Post-cancellation step, winding up proceedings. Following the cancellation of the license, the RBI has stated that it will apply to the appropriate High Court for initiating winding up proceedings against the bank. Winding up is a legal process through which the entity is formally closed, its assets are realized, and its liabilities are settled in accordance with law. 6. Protection of depositors and repayment assurance. The primary concern for the public is the safety of their deposits. As per the RBI press release, the bank has sufficient liquidity to repay its depositors. This indicates that the issue is not insolvency but regulatory non-compliance. Depositors are expected to receive their funds during the winding up process in accordance with applicable legal procedures. 7. Distinction between bank and Paytm app. It is crucial to distinguish between the bank and the application. The banking entity, Paytm Payments Bank Limited, is the licensed institution regulated by the RBI. With the cancellation of its license, it can no longer carry out banking activities. However, the Paytm app is operated by 197 Communications, which is a separate entity and continues to function independently. 8. Continuity of UPI and partner bank services. UPI and payment services on the Paytm app are facilitated through partner banks such as State Bank of India, HDFC Bank, and Axis Bank. Therefore, if users are linked to these partner banks, their UPI services may continue, subject to regulatory permissions and operational arrangements. 9. Legal significance and administrative law perspective. From a legal standpoint, this case is an important example of regulatory supervision and administrative control exercised by statutory authorities. It demonstrates how the RBI ensures financial discipline, protects public interest, and enforces compliance within the banking system. 10 Key legal takeaway. This development reinforces a fundamental legal principle: in sectors dealing with public funds, strict compliance with regulatory norms is mandatory. No entity, regardless of its scale or technological innovation, can operate outside the framework of law. 11 Disclaimer. This discussion is for educational purposes only and does not constitute legal or financial advice. This video does not intend to defame any bank or any other entity. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.